in a decision that will reverberate across Jamaica's urban planning landscape and potentially influence legal reasoning throughout the Caribbean. The Jamaican Court of Appeal has delivered what can only be described as a stunning endorsement of post-facto compliance. By reversing the Supreme Court's earlier invalidation of environmental and building permits for a $190 million apartment complex at 17 Birdsucker Drive in Kingston, Jamaica, the court has effectively declared that statutory process is optional so long as the end justifies the means. WAMH Development Limited's project was already 99% complete and reportedly sold out before the judgment was handed down. In that context, the court's insistence on the legality of issuing permits after construction commenced doesn't just stretch credibility, it breaks it entirely. This ruling gives tacit permission to a new normal in Jamaica's planning regime: build first, ask later, and expect absolution. This isn't just a legal technicality, it's a profound failure of governance. The invocation of the 1966 Development Order as a governing framework over the more restrictive 2017 Provisional Order was a sleight of legal interpretation that conveniently ignored the development's real impact on density, community character, and restrictive governance. In a fast urbanizing capital city, relying on a planning document from nearly 60 years ago defies logic and undermines any claim to modern responsive urban policy. The court's narrow upholding of a stop notice, long ignored by both developer and regulator, is nothing more than theater. KSAMC's duty to enforce compliance rings hollow when the horses have already bolted and the stable is now luxury housing. What message does this send to communities? That their objections can be heard but not heeded? That the law can be broken so long as it is eventually complied with retroactively and on the developer's terms? The residents of Birdsucker Drive did everything by the book. They organized, petitioned, and pursued judicial review. The court acknowledged their standing but denied them substance. Their legitimate expectations of consultation were dismissed. Their concerns about overdevelopment were minimized, and their faith in the planning system has been rewarded with a slap in the face. What we are witnessing is regulatory capture by precedent. Agencies like NEPA and KSAMC appear more responsive to developer timelines than to their legal obligations or to the rights of communities. The result is a deep erosion of public trust in institutions that are supposed to guard the public interest. Even more concerning, the ruling sidestepped a crucial fact. The 1966 Development Order, while treated as controlling, is itself more restrictive than the 2017 draft when it comes to density and scale, yet those limitations were also breached. The court's refusal to acknowledge this contradiction points to a deliberate blind spot, one that enables selective compliance for well-resourced actors. This is not merely a technical victory for WAMH Development Limited. It's a broader victory for developers who can afford to gamble on retrospective legality. By blessing the practice of regularizing illegal construction via permit after the fact, the court has effectively enshrined a path to impunity. Importantly, while a Jamaican Court of Appeal ruling does not create a binding precedent outside of Jamaica, it can serve as a persuasive authority in other Caribbean common law jurisdictions. Courts across the region grappling with questions of regularity compliance and environmental oversight and citizens' rights may look to this ruling intentionally or otherwise as a template. This amplifies the stakes and underscores the urgent need to counteract its normalising effect through legislative reform and policy leadership. The Birdsucker ruling also stands in stark contrast to the reasoning in Hopefield Corner Limited v. Fabric de Yunis in 2008, where the Jamaican Court of Appeal refused to modify restrictive covenants that protected the residential character of a neighborhood. In that case, the court emphasized the importance of procedural integrity and proper notice, the enduring value of covenants in preserving neighborhood expectations and aesthetic character, and the risk that a single breach could represent the thin end of the wedge. Hopefield applied what is known as the estate agent's test, considering the expectations of a typical prospective buyer. It recognized that even without tangible economic damage, the breach of planning norms could constitute material injury to a community. This reasoning could and should have guided the analysis in Birdsucker. The contrast between the two rulings highlight a dangerous judicial drift. Hopefield prioritized public interest and legal structure. Birdsucker has prioritized expedience and retrospective compliance. If Birdsucker becomes the new benchmark, Jamaica risks dismantling one of the few remaining legal tools that communities have to protect themselves from uncontrolled urban intensification. The Birdsucker ruling is a wake-up call. Without decisive legislative and policy reform, this case will be cited again and again to justify future breaches. We therefore need clear legal prohibitions against retroactive permitting, modernized planning instruments that reflect contemporary realities, mandatory enforceable consultation processes for impacted communities, and independent oversight to hold state agencies accountable. Urban planning is not simply about buildings, it's about people, place, and process. When those are disregarded, we don't just lose control of our cities, we lose the very democratic foundation on which planning is built. Jamaica cannot afford to let this become the norm, nor can the Caribbean.